Good afternoon. I am Andrea Chisholm with the midday news for this Monday, July 23. Special welcome if you're watching on onespotmedia.com. We begin with an update from the Vybz cartel appeal case. The prosecution is insisting that the trial judge was right for not dismissing the jury when the matter of the bribery of a juror came up in the Vybz cartel murder case. In the appeal court this morning, Senior Deputy Director of Public Prosecutions Jeremy Taylor continued to rip into the arguments made by lawyers for the appellants. Mr. Taylor told the court that it cannot be said the trial judge's failure to discharge the jury amounted to miscarriage of justice. He said there was nothing wrong with the procedure used by retired High Court Judge Justice Lennox Campbell. Justice Campbell decided to warn the jurors about their oath when the bribery matter was brought to his attention. Lawyers for the appellants have been arguing that the accused men were tried by a tainted jury. Cartel is appealing the life sentence imposed on him in 2014 for the murder of Clive Lizard Williams on August 16, 2011. Sean Campbell, Andre St. John, and Kahira Jones were also convicted for the murder.
Primetime News.
Special welcome to folks on onespotmedia.com.
Up first this evening, prosecutors today ripped into the arguments made by lawyers for the appellants in the Vybz cartel murder case.
The prosecutors slammed the arguments made against the admissibility of cell phone evidence, prosecutorial misconduct, the trial judge's summary of the case, as well as concerns about a damning text message.
Cartel is appealing the life sentence imposed on him in 2014 for the 2011 murder of Clive Lizard Williams. TVJ's Vashon Brown is covering the appeal and was in court today and now reports.
4 days of arguments by the lawyers representing the appellants. Today, it was the time to hear the prosecution's side of the story. First up, the controversial text message. Assistant Director of Public Prosecutions Orette Brown told the court that although the file with the chop-up message was created on July 6, 2011, 6 weeks before Lizard's murder, that specific message was dated August 19, 2011. In other words, the prosecutors said that there was no direct evidence to say that the message itself was modified or tampered with. So put another way, the prosecutors told the court that the date and timestamp for the message were intact. Note too that August 19, 2011 is 3 days after prosecutors say Lizard was killed. The file with the text was also modified on September 30, 2011, after the phone was taken from Cartel. Mr. Brown said even if there's a question of possible modification of the controversial text, questions of possibility are for the jury to decide. The second issue, the admissibility of cell phone evidence. The Assistant Director of Public Prosecutions today argued that the judge was not wrong for admitting the evidence. He said gaps in continuity are not fatal to the Crown's case. It's a matter for the jury to decide. He further argued that gaps in continuity do not speak to admissibility. It affects weight, sufficiency, and cogency. Now, the gaps in continuity issue came about because of the argument that the cell phone was being used while it was in the custody of the police. In the 2014 trial, a police investigator admitted that there was an outgoing text message on the phone on October 1, 2011, which read, "Who am I?" Note here that the police took the phone from Cartel on September 30, 2011. The police investigator explained to the court during the trial that the text is a way some telecommunications company established the identity of a mobile device. Today, the prosecution maintained that the use of the phone was not malicious. The investigator also admitted that there were 3 outgoing calls on October 9, 2011. In explaining why, the investigator told the 2014 trial that perhaps the phone dialed itself. Today, the Assistant Director of Public Prosecution said, "I will not attempt to advance an explanation." He again pointed out that there was no direct evidence to suggest that the phone was tampered with. He pointed out that in the absence of direct evidence, then it's only a possibility. Matters of possibility, according to the prosecution, are for the jury to decide. The prosecution also argued that the judge in his summation gave proper instructions to the jury about how to treat with gaps in continuity, telling them that they must be satisfied beyond a reasonable doubt. The Crown has also insisted that the jury was given adequate directions by the trial judge about how to deal with contradictions as well as credibility of witnesses. Credibility again, as the prosecution argued, is a matter for the jury to decide. Now, the lead prosecutor, Senior Deputy Director of Public Prosecutions, Jeremy Taylor, also made oral submissions today. He took on the specific issue of prosecutorial misconduct, specifically relating to the actions of the Director of Public Prosecutions, Paula Llewellyn. The DPP has been criticized for being prepared to allow the appellants to be tried by a jury that was not impartial. Mr. Taylor said there was no evidence that the DPP acted maliciously. The appeal continues on Monday. Vashon Brown, TVJ News.
On a scale of 1 to 10, what are Vybz Cartel's chances of walking free at the end of this process?
Anthony, you know, that is something a criminal lawyer can never answer. We don't know.
You know, there's a perception in Jamaica that depending on who you are in society, justice is administered in different ways.
Depending on who you are in this society, the outcome can vary. What we expect is that the lawyers would have put sound legal arguments before the court, and the court will view them and dissect them and come up with a decision.
Rock and Salt Hill, both today and yesterday.